Hello, everyone. Happy Friday.
Hello, hello.
Hi.
Hello.
So my name is Christina Jimenez, and I am an attorney over at the Jimenez Law Firm. Everyone else, introduce yourselves.
My name is Josh Floyd. I'm also an attorney at the Jimenez Law Firm.
I'm Julie Prentice. I'm also an attorney at the Jimenez Law Firm.
And I'm James Palin, and I am an attorney at the Jimenez Law Firm as well.
And so today we all may be very low energy because we just got back from our annual conference for advanced family law. And so that kind of takes a toll. So our apologies. We're going to try to be a little bit more lively, guys. I'm going to need everybody to drink your Red Bulls and your Monsters and let's roll. So every Friday we come together as a group and we discuss some complex legal topics. You'll see as we kind of go through this that most of the time Floyd and I can't really agree on much of anything.
And I'm usually right.
And so there is always going to kind of be different opinions and different perspectives. Most of the time we don't have all the facts, and we would like to have more facts to be able to kind of give a better answer. The point of all of that is that you should not take this as legal advice, okay? If you find yourself in a situation of either family law or criminal defense where maybe you do need to go and get legal advice, please go and find an attorney in your area that practices in the court that you are going to be in, because that is always going to be the best advice that you can get. And this is basically just an opportunity for us to provide tips and things of that nature. Am I like real slow on y'all's end?
You're just slow in general, I think, but
You're
nothing
coming
out of the ordinary.
Okay, awesome. Okay, well, I'm getting like weird feedback from you guys. So with that being said, also, please do not forget to follow us on Twitter, Instagram, TikTok, Facebook, LinkedIn, etc. Anytime that we can spread information, we always think that that is going to be beneficial and helpful to people. So with that being said, who wants to answer the first or ask the first question?
I can ask it. I'm down. Are we ready? Who's going to answer it? That's the question. Can we get somebody credible to do the answer?
I'll answer it. Thank you. I got it. I
guess that's a no to my question. All right. So can I press charges if my ex violates a permanent injunction? Under our divorce decree, my ex-husband has 3 permanent injunctions against him. So since Sunday, he has not returned our 13-year-old son and hasn't brought him back. Okay. I need to know if and how to proceed with pressing charges, because under Texas Penal Code 2503, he should not interfere with child custody. I'm still fighting to get my son back because I want him home and he has school starting. My ex doesn't even live close enough to bring him every morning, and I am the sole conservator. What saith you?
Wow. Okay. I like this
It's a good one. It's a good one. I'll answer it, actually.
You can't read and answer. That's
Okay.
against the rules.
Then I'll pull a CJ and I'll take over the question mid your answer and really be the one that answers.
Oh, okay. All right. Go ahead, Floyd. Why don't you go ahead and just take
No, I don't want it anymore.
since you're very excited about this, you're passionate about this issue.
I don't want any.
Okay. So it's a good question because a lot of people don't know about the penal code provision when it comes to interference with child custody. Is that why you thought it was a good question, Floyd?
Yeah, so that, and then, well, the injunction portion of it really isn't that relevant based on what's going on here, but how she can go about getting the child back. And it's just it's a fun case.
Yes. All right. So let's start off with the penal code provision of interference with child custody. So it is a thing. And in 14 years, even though I have had several motions for enforcements filed against my clients, and I filed them against opposing parties, probably almost in the thousands if I had to guess. I've only seen 2 cases where the police have actually filed interference with child custody. And one of them we were able to get dismissed, and the other is kind of an ongoing sort of situation. It's just extremely rare that police will get involved. And most of the time, what will happen when you call a police officer or sheriff's department and you say, hey, he has my kiddo, my 13-year-old, who's refusing to return the child. The police are going to tell you that's a civil matter. You need to contact a lawyer. We're not going to get involved. I think the reason why they do that is because essentially that penal code provision requires them to interpret a court order, and they're not lawyers, right? And so, and in both of the situations where charges were actually pressed, the order that they had, or what they had perceived to be an actual criminal offense, wasn't actually a criminal offense. And so I think that's why they kind of just don't touch it. But it is a thing. It's a state jail felony, right? Yeah, so you can be arrested for a state jail felony. The one case that we had that was ultimately dismissed, that happened several years ago. And I think the reason why that particular individual was arrested was because the officer went to the residence while the dad was trying to pick up the kiddos and told her, if you don't give these children up, I am going to arrest you for interference with child custody. And my client was basically like, okay, you have to do what you have to do. They're not going. And then she got arrested. And so typically when I see like those types of incidents, it's because there was some sort of a warning that took place, and the mom or the dad, whoever, just decided they weren't going to listen. But there were some technicalities in that order that we were able to use to get it ultimately dismissed.
Also, on that one, I think it's important to point out that dad in that case may have known somebody that knew somebody.
Yes, yes, there was, and typically when you see that, it's a situation like that, right? Because most officers, and Julie, I mean, you were at the DA's office for several years. I mean, what was your opinion as a DA?
You're absolutely right. We didn't like those cases, and we didn't take them unless we had to. It had to have been a very clear violation of the order where the parent was trying very hard to keep that child away from the other parent. And you're absolutely right. Normally did the officer give them a warning, tell them you do this again, you're going to jail? And then at that point, if they still did it, then it would get filed. And even then we would try to work them out because we had other stuff going on that was as serious as that is. It's
There were bigger fish.
Also control discretion.
So yeah, I mean, you can try to go to the police station and make a report. I think it just depends on the county too, and it depends on the officer also. And it also depends on how egregious it is. And it seems as though in this case, it's been a while that I guess she doesn't say, but basically dad's just not returning the kiddo. I would say the other reason maybe why police officers don't get involved, and this is sheer speculation, but most of the time when you have situations like this, maybe mom tries to go and pick up the kiddo and the kiddo starts crying and says like, I don't want to go with mom. I'm afraid of my mom, or I'm afraid of my stepdad or whatever. And then if this officer is putting this kiddo in a really unsafe situation, I don't know that they want to put themselves in that situation. So best bet is going to be to do what, Floyd?
I would follow writ.
What is a writ, Mr. Floyd?
See, that's why you shouldn't answer the question, because I knew you didn't know. So I would file a writ of habeas. Basically what it is you file pleading with the court, explaining to the court that you have a superior right to possession based on the prior order. And since in this case, she was appointed as sole managing conservator, she would have that right unless it's on like a weekend or summer, whatever. But anyway, so you would file the writ, and the judge has two options. The judge can issue an order ordering in this case, the dad to deliver the child to the court on a date certain for the court to determine who has the right to possession of the child. And then she'll give the child to whoever has the superior right. Or the judge can issue an order. If you can establish that the child is in danger, right, then the judge can issue an order ordering the child to be turned over to, in this case, mom. With that one, they can also issue a writ of attachment, which would give the officers the ability to take physical possession of the child.
So your answer got a little bit confusing. So you're saying if mom can establish that the child is in present danger with dad,
Correct.
okay, then she could request a motion to modify orders temporary and request a TRO, extraordinary relief, and then request a writ through that?
No, you still do it in a writ of habeas request, right? There's two options the judge has on a writ of habeas. One is order the child to be delivered to the court. The other is order the child to be delivered to the parent, right? If you're going to order the child to be delivered to the parent, it's essentially the same burden as you're talking about under TRO extraordinary relief. You have to meet that burden under the writ in order to get the judge to order the child to be delivered to a parent. If you can't meet that burden, then the judge will just set a hearing, usually pretty quickly, within a couple days, and have the child delivered to the court, and then the court will go from there.
And so with regard to the habeas, when we're talking about superior right to possession, you have to, and we've had that come up before where, you know, if let's say hypothetically dad has summer visitation with the kiddo and mom is refusing to allow dad to have that summer visitation. And then dad, you know, waits several weeks to come in and we file our writ of habeas. But then by the time we are able to get her served and get a hearing schedule and whatever, the summer of possession's almost over. So be mindful if you're going to go the writ of habeas route that you're actually going to be entitled to possession at the time of the hearing. Because if not, then that all of that work and all of those attorney's fees are going to be for nothing, right? And so in this particular case, I think more than likely, just because she's not saying that he's in any danger, you would have the writ of habeas hearing. Both parents would be ordered to appear, and then the child would more than likely go with mom. Now, let's assume she goes to the police station. They tell her, get out. We're not filing anything pursuant to the penal code. What else could we do?
Wait, so real quick, let's go back to the no danger thing, right? So she may have an argument if the child is missing school to meet that heightened burden, right? Because the child's about to begin school. And so if dad's not taking the child to school, to the school the child's enrolled in, or has withdrawn the child or something without letting her know, that might be enough to get the child delivered to mom.
Maybe. Yeah. It depends on the judge. And that's why we always say, like, if you're in this situation, find local counsel, because I know that there are some judges that would say, no, that's not going to be enough. But then there's also other judges who are like, no, absolutely. Like that's not okay. So going back to what else they can file. What else would you file? I know what I would file. Anybody else have any ideas?
Like in an attempt to get the child back, or
No.
Okay. Well, I know what I would file. Does anybody else have any ideas? I'll file an enforcement and a modification.
Yeah. What's an enforcement, Mr. Floyd?
So I don't feel like I'm as knowledgeable on this as Mr. Palin. So Mr. Palin, that's to explain enforcement.
Well, yeah, and enforcement is basically when you say, hey, judge, you gave us an order and somebody's not following it. So we need you to come in and make sure that your orders are being adhered to and, you know, lay some punishment down on the folks who are being disobedient.
And I think verbatim, that's the way Mr. Palin files it. Like, hey, judge, there's some bullshit going on. Let's get it fixed. I think verbatim, that's what he puts in his pleading.
But I mean, but that's the way they come down, and you know, those violators are in for some pretty serious consequences.
Yeah, so it is important when you file these motions for enforcement that you are filing them with specificity. So I had a case over in Dallas, and my lady was absolutely good for it. So I represented mom, and there had been some violations, and the problem was, though, when the attorney drafted the motion for enforcement, she didn't plead it correctly. And so I let the judge call the case. We kind of started the hearing. And then after that, I requested that the court dismiss the case. And they just told us this at Advanced Family. Did y'all catch that? It was like motion for acquittal of something. Y'all remember that? I'd never heard that before.
Yeah.
What is it?
Motion for judgment of acquittal.
Okay, and so I just moved to dismiss the case with prejudice, and clearly that was not correct, but I still got what I wanted, which was, judge, they didn't plead it correctly. This is a quasi-criminal proceeding, and therefore you have to dismiss it. And the judge was like, absolutely right. Like, she couldn't hold my lady in contempt of court. She couldn't put her in jail. And so when or if you're in the situation, you got to make sure that you're hiring a good attorney that knows what they're doing, because otherwise you pay all this money just to walk into court and for the case to be dismissed because things were not pled correctly. So
when you're selecting attorney on enforcement, make sure they know what a motion for judgment of acquittal is, right?
Right, or just like know how to ask for a judge to say, like, get rid of this, please, judge.
So I had a similar situation. And I made a similar argument, but judge would not dismiss the case. He said, I'm not going to hold her in contempt because you can't meet the burden, right? But then that's when I realized that actually dismissing the case at that point is really not proper. What would be proper, the proper way to go about it would be they would then amend their enforcement, and then you would make a double jeopardy claim, right? Because it's already been litigated. Right. So double jeopardy attaches because it's quasi-criminal. And so on the enforcement, if they didn't plead it correctly, the judge just can't hold them in contempt. That's the remedy, right? It's denied. So then they have to file another motion for enforcement in an attempt to fix their pleading. At that point, jeopardy had already attached. And so then you'd move for dismissal on a double jeopardy claim.
Unless there's another violation.
Right, that's not contained in that prior enforcement. Correct.
Yeah, and that's, with that case, the judge was very kind to tell opposing counsel, well, you stopped in October in your motion, so if she violated in November, December, January, feel free to replete or to file a new motion. So that's the story for another day.
I don't think that would work.
I don't know. I mean, I think that it would potentially work. I have never made the double jeopardy argument. I remember us talking about that whenever all that stuff went down, because that was kind of weird. But as far as getting a case dismissed, I've had that happen several times, and judges are like, yeah, it's just not sufficient notice, and so on and so forth. So anyway, make sure that you hire a good attorney to pursue those charges. The other thing that I'll say is, if let's say your dad, and you're trying to exercise visitation and mom is denying visitation, it's not enough to send mom a text message and say, hey, I'm headed your way. And then mom says, F you, I'm leaving, we will not be here. And then you just don't show up. Okay. You have to go to the place where it's ordered that the exchange occur. You have to be there at the time that you're ordered to have the exchange occur, because if you don't do those things, then mom cannot be held in contempt because you didn't show up. So in this particular case, mom doesn't have to try to show up to get the kiddo back, because dad had the duty, more than likely, to surrender the child on a certain day at a certain time at a certain place, right? So he's already in violation.
DJ, to that point, so what effect, if any, does permission have on either the writ or even the modification? So, I mean, we're talking about people and their kids. So, and we always encourage co-parenting. So if mom says, okay, well, hey, fine, I know it's not your period of possession, but you can have him an extra day, and he stays 2, 3 extra days, right? I mean, do you still have your same footing when going for your either enforcement or your writ of habeas?
I think it depends on, so let's say hypothetically speaking, that mom says you can have one extra day, right? And then that day comes and goes, and after that, dad refuses to return the kiddo, and mom's entitled to possession that second day, right? Then at that point, that is a violation of the order, right? Because you can deviate from a possession schedule by mutual agreement. But if there's no mutual agreement, then you got to follow the order, right? Or I think it gets a little bit kind of fuzzy, and where I, will often encourage people to not move forward with enforcements. Is I've had this situation where like mom and dad will say, okay, yeah, you can agree, I'm going to give you this extra week. And then something happens, and then mom gets pissed off and says, never mind, you can't have him this extra week, and you need to bring him back to me tomorrow. And dad's like, hey, I'm in Florida on vacation, I can't give him back to you. And then I get the call of, well, I want to put him in jail because he's not following the order. Mm-hmm. That, I think, that's what I'm saying. It just kind of depends. I don't think dad would go to jail in that particular case. I think judge would probably, Floyd, you disagree. You can tell by your little face.
No, I agree with your latter statement, but I was going to mention on the first one, right? I think, so she says you can have an extra day, and he doesn't return that day. I think he may have trouble enforcing that, right? Because he's not violating an order, he's violating an agreement. So is he in possession when he otherwise is not entitled to possession? Yes. But did he fail to return the child at the date and time as set out in the order? No, because it was an agreement to extend that. But I guess the provision he would violate would then be the language at the bottom that says mom has right to possession at all other times. I've never moved forward on enforcement with that language.
Well, and I would argue, and that is, I don't know that I've ever had an enforcement like that. And if I have, I don't remember, but it always gets tricky when you have this mutual agreement step. And then when was he supposed to get back? When was he not? But if the order states that dad's only supposed to have possession and access on first, third, and fifth weekends, Friday 6 to Sunday at 6, and it's, Tuesday morning, and he's still refusing to give the child over, I think most judges would enforce that if it's mom's period of possession.
So, but for an enforcement regarding possession and access, you have to specify the date, time, and location for exchange where he failed to exchange. Mm-hmm. Right? But based on their agreement, he wasn't supposed to exchange at the date, time, and location set out in the order because they agreed otherwise. Right. Maybe you move forward on it is ordered that the parties have possession as mutually agreed upon. So then their agreement basically becomes the order, like it's ordered that that's what it is.
I wouldn't move forward with that's probably why I'm like, I don't think we've ever done it, because I don't think that a judge could put or would. The question of could is different. I don't think they would put someone in jail because it's very hazy. Very, very fuzzy.
But you still can move forward on the writ. You still can get attorney's fees as a result of the writ, right? The question is can they be held in contempt? I don't know. It'd be a fun one to argue.
It would be a fun one to argue. And obviously we'd have to do research on it. But in this case, they didn't have an agreement. He's just refusing to bring the kiddo back. So I'd absolutely think an enforcement would be warranted. And then you said a modification. What are you thinking on the mod?
I mean, God, it really just depends on a whole bunch of things. But if he's living far away, then maybe you restrict daytime only to the county where the child resides or something. If it's just been one violation, I'm only talking about a couple of days late, I don't know that you get that on a modification, right? But if
But I
it's,
think it depends why too. Like when you're dealing with a 13-year-old kid, I feel like there's something going on.
the 13-year-old doesn't want to go back to mom, that's what it is.
Right.
And so if you open yourself up to a modification, you got to be careful.
I'm sorry, Floyd, you said daytime only in the general facility or the county where mom lives?
Yes.
Okay.
Well, yeah, because the argument is look, Judge, you need to restrict him because we can't trust that he's going to bring this kiddo back when he's supposed to. And so sometimes when I have situations like this, and it depends on how egregious it is, but sometimes we move for them to be at a facility because, look, Judge, it's now the second or third time that we've had to pay thousands of dollars in attorney's fees because he doesn't know how to follow the order. So now he needs to be at a facility so I can be guaranteed to get my kiddo back, right? And I think the courts look at the facts of the situation too. So we had a case where we had just filed a TRO, extraordinary relief. We could not find mom for the life of us, but we had sent her emails. Our client had sent text messages. He had sent her Facebook posts. He had sent the TRO to extended family members. We were putting her on notice of, you have to, pursuant to this order, return this kiddo to dad, right? And in that case, because she wasn't served, there was no way we could have moved forward with an enforcement. But when we were actually able to get her served and we were actually able to get into court, the fact that it had been like 3 or 4 weeks that mom had been put on notice, that judge had signed an order saying that this kiddo needed to go to dad, that was enough for that judge to say, hey, now mom needs to be restricted or have, supervised access, because she knew there was an order and she just didn't follow it. So you got to be careful. Like I have situations like this all the time when, parents will come in and say, well, I didn't let the kiddo go because, the dad is an alcoholic or the mom had her new crazy boyfriend around or whatever. That's not enough. Like, you don't just get to disregard court orders. You have to hire an attorney. You have to file motions to modify, and you got to get the court's permission to deny possession.
Yeah. And I was going to say the same thing on the reverse side, right? I mean, I've had clients say, my child was 13, he doesn't want to go. And at age 12 in Texas, they get to choose. No, that's not true. They get to choose in court, right? You've got to follow that court order. And so the right move for dad in this case, if in fact that's the case where the 13-year-old doesn't want to go home, is to return the child, file the modification, let the child go talk to the judge and get an order that says you have the right to possession. But just because the child doesn't want to go does not alleviate you from being required to follow the order.
Right. And those are always really tough conversations to have with clients because they're like, it's going to break my son's heart and I can't tell him this. And I don't want him, to feel like I don't love him and, all that stuff, which I understand. But unless and we've had that happen too, where the kiddo's like, if I have to go back, I'm going to run away or I'm going to do something to myself. If you have stuff like that, you can move forward with a TRO extraordinary relief, right? And a TRO extraordinary relief is basically where you sign an affidavit and you say, look, judge, if you make this kiddo go back with mom, he's going to suffer significant impairment, right? He's going to be in some sort of danger. And the judge reads the affidavit. And when the judge reads the affidavit, she thinks that, yeah, this kid is probably not going to do well going back to mom's, then she'll sign an order basically saying on a temporary basis until y'all can get into this courtroom for me to hear all the evidence, this child's going to stay with dad and mom's not going to have any visitation. But if barring something like that, you got to say, son, I'm sorry, but I have to follow the order. Go back to mom's. I'm going to hire a good lawyer and we'll figure it out in court.
Yeah, because if you don't, it's really going to break your son's heart when you go to jail for 180 days for violating the court order.
Right. And that's a thing. So I guess we can talk about that. Like what happens on enforcements? Like what are some of the things, the consequences of not following the order?
Julie, do you have any idea?
$500 fine and up to 180 days in jail for each violation.
Oh.
And they can be sacked.
One
Ma'am?
more. mandatory attorney's fees too,
Mhm.
which that really, like, you're gonna be paying for her lawyer to put you in jail. That's fun.
Make up possession.
And make up possession, yeah. So,
A long time.
And I've never done this, but you can make an argument to get attorney's fees under the writ and under the enforcement. But I don't know if I've ever done that.
right, right. So if your dad's attorney, obviously you tell him, unless there's some significant impairment, give the kiddo back immediately, and you just move forward on a motion to modify. But if the child is in fact in danger, you would do the extraordinary relief, ask that you be allowed to keep the kiddo on a temporary basis, and then hopefully go in and get primary conservatorship. That might mitigate the enforcement, might. If you go in and you say, like, kiddo was in danger, this is what he told me, and I was trying to get a lawyer, I would never recommend doing it. But I mean, we've been put in those positions before where client has the kid for 2 weeks, and by the time we get him, it's like, you're probably going to go to jail. And so we have to move forward on the modification. And then, we've had some success with that, but that's
I think
scary.
it depends on the timeline and, whether CPS was called and yeah.
Yeah. What
Fun
else?
question. It's fun. So permanent injunctions, no, you can't be charged like penal code wise for violating a permanent injunction. But she didn't mention any permanent injunctions, but just generally, yes, you can file an enforcement if someone violates an injunction, but I don't know what those are in this case.
Right,
But that was her question.
right.
Hmm.
James, you want to read question number 2?
Before we do you think it's important to let people know that they should follow us on the social media platforms?
I did.
Did she?
Yeah, you need to listen. Pay attention, Mr. Floyd.
Are you sure?
Yes, I'm positive. I did
We're gonna
that.
ask the community.
Yes, it was done.
Okay. Go ahead.
James, go ahead.
Just in case, Twitter, IG, Facebook.
Thank you, James.
How can we quickly get a person out of the house that we know is a danger to other people living there?
So
Very-
before you read this question, I would avoid like the specific names because they give specific locations and specific names of people. So you might come up with initials or something for those.
I'm gonna get creative. Here we go. Y'all ready? All right. We're interested in how we can get a person out of a house that we own. And the situation is as follows. The house is in Denton, and our daughter, Lil Kim, has been living there for several years. Now, Lil Kim agreed to provide her friend, Lil John, and his girlfriend with temporary accommodation, but that has turned into a nightmare, with Lil John not only constantly hassling Lil Kim, who it has become clear that he hates, oh my goodness, but also threatening Lil Kim with a hammer and his brother, Mystical, with a knife. The result is that
Did
Lil
you say
Kim,
mystical?
hey, it's throwback.
How old is mystical?
Danger. Y'all know, come on, y'all
That's
know.
like a decade ago. I guess all of them. They're probably like 20 years. James, you're showing your age now. You're showing your
I'm doing my
age.
best. I'm just trying to relate to our audience. All right. We also got Lil Yachty. Would that help? Y'all don't know who he is. All right. So, but that is where were we? Okay, but also threatening Lil Kim with the hammer and his brother, where we at? Mystical with the knife. The result is that Lil Kim is no longer feeling that she can safely live there, has been staying with a friend. We want to know then, how can we get Lil John out of the house as quickly as possible? What do you think?
Julie.
I mean, first of all, quit associating with people named Little John. That's a problem.
Good advice.
Let those people come in your life. You get this. No, there's a couple ways you can do it. So since they live there now, the civil remedy would be an eviction notice that you would have to file. with the court, get the notice served, and then they'd have 30 days to move out. The slightly quicker version, if you can report it at the time that they're threatening you with a knife or a hammer, that's aggravated assault with a deadly weapon. And most jurisdictions will issue a 30-day protective order, limiting them and excluding them from the residence to protect you. Little Kim, I think, is familiar with those. She's had some good experiences in her life. Not that she would need them. She's bad. She's bad, but she can take care of it.
Beep. Where's the beep thing?
Beeper.
I think you needed it for you earlier. I'm just saying.
No, so we figured out we're allowed to say shit and damn.
Oh,
Yeah.
that's the limit. My
Okay.
bad. All right, so yeah, we need to censor me. But they'll do an emergency protective order and help with that. And then you can also file for an extended protective order, which is another option. So there's actually a couple different ways you can do it.
So if, let's just say hypothetically speaking, like there's no like recording or video or something of this guy allegedly threatening her with this. I mean, I understand that people can make reports even without that type of evidence, and it's going to be up to the discretion of the officer. But let's just say, hypothetically speaking, that an officer says he's denying it. There's no other witnesses. I don't really believe you for whatever reason, and they don't pursue any charges. What else do you think?
And then at that point, I think you're looking more the eviction route because you have allowed him into the home. It is his residence now too.
Do you think, what about just like a regular old protective order?
So I think you can try for it. You're gonna have, I think, some problems if you don't have enough for even a police officer to go forward. I think you're gonna have trouble getting a protective order at that point. But you can always try because a threat is enough to at least try. So it's a threat plus it's violence plus future or threat of violence plus future or
Right,
stalking.
right. Yeah, that's what I was thinking when I was reading it, is just doing just a straight protective order.
Can't you do a protective order under the Code of Criminal Procedure for harassment?
Stalking. Harassment alone
Harassment.
isn't enough.
They live together.
Not harassment though, you can't?
Harassment alone is not enough. It actually has to be stalking. Or, sexual abuse or any of those under Chapter 7A.
Well, at least that way, I mean, so maybe it's not enough when you get to court, right? But you can get an ex parte kick out order to get him out of the house quickly and then go to court and lose, right?
Yeah, that's true.
And then you have him come back in the house after you kicked him out with a hammer and knife. Oh, no.
Well, that'll give you a couple weeks to get your crap out.
During that time, you get all your stuff.
God, that's terrible. That is really terrible. All right, next question. Julie, you want to read that?
Yeah. How can I transfer my custody and support case from one state to another? How can I help my child through this? I moved last month in order to have a better work opportunity and to purchase a home. My 13-year-old made the trip with me. There is no custody ordered. However, there is child support. It's ordered at 0. No one is in arrears. My 13-year-old is absolutely refusing to return back to their mother. The other parent would like him to return for one more school year before allowing him to move here with me. I'm on board with co-parenting, but our child is physically refusing to go. My son feels unsafe in the neighborhood due to the homeless encampment on the corner and isn't allowed outside without his grandmother. When he's here, he's safe. He still wants to visit the other parent. He just doesn't want to live there. How can I transfer my custody and support case from one state to another?
This me?
Floyd.
Yeah, I think so.
The good news is you don't need to. Because child support, an order for child support alone does not establish continuing exclusive jurisdiction. However, in the new state, you will need to reside there for 6 months before they'll get jurisdiction under the UCCJEA. So once you live there for 6 months, then you can file an initial SAPSR in that state and litigate it there.
And if you represent mom, you're gonna want to move forward quickly and
I
file.
got confused on the question. So mom is the one that moved away?
I think it's dad, no?
Yeah.
I think dad moved away.
Refusing to go back with their mother.
Yes, there you go. So dad moved away and then mom's still in that state. And so if your mom's attorney, you want to move forward quickly to file the initial suit affecting parent-child relationship. And at that point though, how long have they been out? A month? At that point, it's discretionary, right? So let's talk about home state. So the way that it works when you have a kiddo that has relocated between two states is you have to figure out which state is the actual home state. And the rule is where the child has resided the 6 months preceding the filing, that's the kiddo's home state. Okay, so if she's been in Texas, moved from New York to Texas, she's been there for 6 months, that's easy, right? Where it gets a little bit convoluted and where I always have to pull out my handbook and look at it to make sure that I'm right is when you have a situation like this where she had, let's say, been in Texas and then she moved to New York and she's been in New York for a month. I think at that point, Floyd, it's discretionary and we go to the significant contacts, etc.
I do not believe so. I believe that it automatically defaults back to, so I think it says that if the child has not resided in a place for 6 months, then it's the location where the last location where the child did reside for 6 months or something along those lines. And then it goes into the other stuff that you were talking about.
4A 2.2.
What's the page number on that? God, it would be nice if they had that on here.
It's 340 around there. So 2.2.1. Yeah, I hate that they do it this way. So the child has no home state. No other state was the child's home state during the 6 months before the child custody suit was commenced or on the date the suit was commenced. Then it goes to significant connection and substantial evidence. Yeah, I think that's the test. Obviously, when you hire an attorney, make sure that they look at the code book and they verify that that's correct. But I think what the courts have to do, and most of the time when there's a home state jurisdiction issue, what'll happen is the judge in New York will confer with the judge in Texas, and then between the judges, they make a determination as to what is going to be the most appropriate for them, right? And then they'll say, all right, I'm releasing jurisdiction to New York, or I'm going to release it to Texas, and then from there, that court will then be able to make an initial custody determination. Floyd's determined to prove that I'm wrong. He's to keep looking, Floyd, it's okay.
Well, yeah, you guys go on.
With that being said, if I'm mom, I file immediately because then I'm going to argue, well, they've only been there for a month. They, his school was here, he's been living here, etc. I don't know that it matters. I think it is a strategic advantage if you can file it where, like if you're representing mom having the case in Texas. I think that judges are more inclined to keep the kiddo in Texas. They want to keep the kiddo within their jurisdiction. But I also, anytime I have a situation like this, I typically will find local counsel in whatever other state I'm dealing with because I want to know where do we have the better chance, right? And if I lose, like, what are the child support guidelines there as opposed to in Texas? And so is this the jurisdiction issue something that I'm gonna want to argue, or would I potentially be better off just allowing it to go to New York? Right?
Okay, and CJ, when you are filing, you're not filing for a geo restriction because this person has already moved.
No, I would still say that you have to move forward with the geo restriction. I would absolutely request a geo. Now, would you get it? I don't know, but I think that I would definitely ask for it. So, and I think, you know, we have these types of cases all the time. Anytime where you have a parent that has, especially if you're dealing like interstate and they go across state lines and they're like, I'm moving, and he says, my 13-year-old made the trip with me. And so the way that that's phrased, it's not like a mom agreed to allow him to come with me. It was like, hey, I'm going to go with dad to make the move. And then he just never came back. When you have that type of situation, judges are not very happy with you when you walk into their courtroom. He didn't technically abscond, right? There's not a court order, so he's not violating an order, but that's not cool.
Okay.
Yeah.
Do you want me to tell you I was right now or wait until the end?
You can wait. We have 22 more minutes, and then
Okay, we'll talk about that.
and then we can talk about it. So
Okay.
tell me, what's the answer?
Yeah, so if I guess I'll just read what it says. So a Texas court has jurisdiction over UCC JEA child custody determination if Texas was the child's home state within 6 months before the child custody proceeding was commenced, and a parent or person acting as a parent continues to live in Texas, even though the child is absent from the state. And it goes to an example where the petition was filed like 4 or 5 days after one of the parents moved the child. Texas still had jurisdiction because it was the home state within
Because
the past
the
6
parent
months.
stayed there.
Yeah, and one parent stayed there. Yeah.
So then, under that reasoning, if dad was living in New York for 5 months with the kid, you're saying that Texas would still be the home state so long as mom stayed there.
Yeah, because it was his last home state within 6 months preceding date of filing.
Okay.
So 6 months and a day, then that's when that debate between the judges from New York and Texas occurs.
I think that's when home state is now New York. You wouldn't get under this provision because it says within the 6 months preceding date of filing.
Yeah.
Remember earlier when I said I was right when we disagree? I said at the beginning of the video. Okay, so while she tries to figure out how she was right, you want to go to the next question?
That doesn't make any sense to me. It's not logical.
Page 338.
I know, I'm looking at it.
But Floyd, we had a case where our client had taken a kid and gone up to like, let's say Nebraska. And I was tasked with speaking to that judge to reach out to the judge here in Texas in order for the hearing to take place over there. And they had that back and forth.
So yeah, it depends. So maybe the child in that case, I don't remember the facts, but maybe in that case, the child didn't have a home state. So the child had never lived anywhere for a period of 6 months. Right.
But that's part of the significant connection test. So they're still evaluating the significant connections.
No, significant connections is below that.
Oh, look above that. B1B. Subpart B is significant connection.
No. All right. So you have home state jurisdiction, which is A, right? And then you have, so that's A, and then you have all the subsections, 1, 1A, 1B, 1C, C1, and then 2. And this is 2 Two. It's two. And then B starts significant connections jurisdiction.
Right, which is a section you were just reading from, Floyd.
No, I'm reading from the top paragraph right here.
You're reading from 2, not B. Is that what you're telling me?
Correct.
Okay, alrighty, sorry.
It's okay. We've got, you said 22 minutes. I'll do the correct math. It's now 9 minutes. We had 12.
God, okay, so I need to research this, and I don't agree with you, Floyd. That doesn't make any sense, but I'll look at it. So have we thoroughly exhausted this question?
I think we have beat that.
Answer the question? Yeah, did we answer it?
Yeah, we don't need to transfer because there is no state of continuing exclusive jurisdiction. We were going into strategy whenever we started looking at UCCJEA.
Okay, so I'll read the next question. Is there anything I can do if my husband forced me to sign a paper saying I'd give up my kids, but I have no proof? He made me write and sign a paper saying I'd give up my kids. I had no idea what I was signing. I honestly didn't read it, but I would like to see if there's anything I can still do. James.
All right, so it sounds like you voluntarily or involuntarily terminated your parental rights, but there's a lot more that is going to be necessary in order for him to move forward with that process, i.e., 2 witnesses, getting it notarized, and then having the proof up. So you have opportunities to make your objections known. In the meantime, in between time, I might even file your leave after. I mean, I don't know if you have orders or what your situation is, but before he can move forward with any of that, you may want to get your options and your preferences in black and white sent over to the judge to move forward instead of all of this foolishness.
Yeah, I mean, that's interesting. I wonder if she signed just like a paper that literally, because it's in quotes, I'd give up my kids. And so I wonder if it's just like a paper that says I'm giving up my kids.
Yeah, it sounds
And
like
she's freaking out about it.
Yeah.
Because if that's what you signed, then don't worry about it. You're fine. Everything's gonna be okay. But if you sign the affidavit of voluntary relinquishment, like James says, you have to have it in the presence of a notary and 2 independent witnesses. And typically you have 11 days to rescind it. But there's also the 60-day provision, right, Floyd? So it's either 60 or 11. So it depends on what that says. And then you can always rescind an affidavit of voluntary relinquishment by sending the notice to the attorney that, in theory, there's always an address and a person where you send the rescission to. So, I mean, you could try to do that if you're within the amount of time. I've had that happen before where allegedly they sign affidavits of voluntary relinquishment and they didn't get a copy of it. And that's always interesting because like we had a case where the client had signed that and they had gone through and they had done the termination, adoption, and the records had been sealed. So then we had to go in and we had to request that the court reopen or allow us to unseal the records. And so then we were able to get a copy of it, and that was more of a child support issue type thing. But we could at least get a copy of it. If nothing's on file, what can she do?
If
File
she,
a SAPSER and then make them bring that affidavit forward.
yeah,
Still file a rescission, maybe sending it to dad, and just in case. Yeah, I guess that's it.
and then notice to the court. I would file it with the court also and serve dad with it. That way it's on file.
Yeah, that's a good one. So I guess just a quick little note. When I have parents all the time that come in and they're like, well, we signed this notarized document and it says that he's never going to see our children again. Or it says that he was going to pay me $3,000 a month for, until they're 18. And now he's saying he's not going to do it. I want to enforce my notarized piece of paper. It's not a thing. Don't do that. Hire a lawyer. Let's get a court order because they can rescind it at any point and it's not really valid for any purpose at all. So
I don't want to say at all, right? I think it
you can
goes.
establish intent and all of that, but yes, I overspoke. It's just you can't put him in jail. You can't make him do it. It's just when you go into a court hearing, you can say, well, look, judge, he said that they could live with me and he was going to have standard visitation and he was going to pay me all this money. And the judge should say, well, that's great, but I'm not going to make him do it. Right.
It's pretty much worth what you paid for that advice on that document.
And also for the dirtbags out here that will, take advantage of somebody's emotional state and have them sign some stuff they're not really reading, nor do they fully understand. That's not cool, man.
Yeah.
James Palin doesn't approve.
It could be an IIED claim, James.
Hey, look, I know a lawyer who will file it.
What does James Palin Sr. think about it? So you haven't changed your Zoom name, Mr.
That's
Palin
true.
Sr. Yeah.
Well, you see, I was going to wait to roll it out on the perfect Friday, but I see no better Friday than now. The lawyer formerly known as James Palin will now only answer to either Justice Jimmy or James Palin Sr. Let it be in the world.
Duly noted, James. So I guess with that being said, we can go ahead and just close out because I don't think we'll have enough time to get through any more questions. And I don't have my disclaimer ready. Does anybody have the disclaimer up and ready? No? Okay, well, I'll go ahead and just give my little spill while I'm pulling it up. So, as we always say during this process, please do not take this as legal advice. As you can tell, we go through these questions off the cuff. And so sometimes, most of the time these days, I have to go and I have to do research and I have to look at my code and I have to think about it, talk about it. Not everybody can be like Mr. Floyd. And so when we're going through and we're talking about this stuff, it's basically just discussing concepts in general. And so it's important that good job, Floyd. It's important that you retain an attorney, you talk to your attorney about your particular situation, and then you follow their advice. And if we're able to give you some tips or some clues along the way that maybe you can discuss with your attorney, then that's great. And that's what we're here for, right? But other than that, I hope that everyone has a wonderful, wonderful weekend.